My name is Kurt Organista. I'm a professor of social welfare here on the UC Berkeley campus and director of the ISSI, the Institute for the Study of Societal Issues. By the way, I don't know how many people are aware, but the ISSI is an organized research unit. It's like an umbrella organization under which are nested 8 different centers. So I just wanted to point that out. Would you guys join me in silencing your phones for about an hour this evening? Yes, it's on silent. And I want to thank our co-sponsors, the Institute for Governmental Studies, the School of Social Welfare, and the ISSI's very own Center for Right-Wing Studies. Right. Very, very prominent there. It's on the right side. You notice that? In fact, our director of that center, Larry Rosenthal, is here with us this evening. Welcome, Larry.
Thank you.
A quick description of the format for this afternoon. After I introduce him, Erwin Chemerinsky, we'll speak for about 30 minutes. Afterwards, we'll engage in some discussion. Folks that are joining us on Zoom are welcome to use the Q&A feature, and those questions will be submitted to me, and I'll try to answer as many as I can. After we finish at around 6 o'clock, all of you are invited to stay. We'll have some refreshments in the back and conversation. I am absolutely delighted to introduce our speaker for this afternoon, Erwin Chemerinsky, who is Dean and Jesse H. Chopper Distinguished Professor of Law here at UC Berkeley. Prior to coming to Berkeley in 2017, he was the founding dean of the School of Law at UC Irvine. He's a prolific constitutional scholar, author of 20 books and over 200 law review articles. His most recent book, No Democracy Lasts Forever, How the Constitution Threatens the United States, published in 2024, is a concise, compelling, and sobering deconstruction of our nation's Constitution. In fact, when I was reading it, it was so sobering, I often had a glass of wine by myself. He is, I go both ways. He is also founder and leader of We Hold These Truths, a new nationwide effort to promote democracy through public education. I hope you'll maybe speak a little bit to that. And finally, I'd like to say that he is a gracious and generous colleague who has made himself available to be with us this evening, even though he has multiple competing demands on his time to speak about our current constitutional crisis. So please welcome Dean Chemerinsky.
Thank you so much for the kind introduction. Thank you for inviting me to speak. Thanks to all of you for coming. There's not a microphone, so if at some point my voice tells off and you can't hear me, just wave your hands or say louder or something like that. No democracy lasts forever. Democracies are there until they're not. We can all identify countries in the world that once were democracies, but are no longer. It would just be hubris to believe that there's something about the United States that would protect it, where other countries have failed. I have never been so afraid or imagined being so afraid for the future of American democracy as I am right now. If there is a path towards authoritarianism in this country, this is it. I want to develop this in 3 points this afternoon. First, I want to say that what we've seen since January 20th, 2025 is unprecedented in American history. Second, I want to focus on a question that we can't answer at this moment in time. Will the guardrails of democracy hold? And third, I want to focus on what it is that we, all of us, might do about this. So why do I say, to begin, that what we've seen since January 20th is unprecedented in American history? What we've seen since January 20th is a pattern of illegal and unconstitutional acts, unlike those of any prior president. We've seen an effort to increase the powers of the presidency, unlike we've ever seen. And we've seen a use of presidential powers for the sake of retribution, unlike we've ever seen. What I want to suggest to you in going through this is not hyperbole. It's the reality we're living through right now. I started by saying we've never had a president who's engaged in repeated unconstitutional and illegal acts as we've seen over the last 9 months. Let me give you some examples of this. The use of troops in cities for domestic law enforcement purposes. There's a federal statute, the Posse Comitatus Act, was adopted in 1878. It prohibits the use of troops in domestic law enforcement situations. It's not coincidence that it was adopted at that point in time. After the Civil War, during Reconstruction, there was military rule over the states of the former Confederacy. There was literally a general in charge of each, and there was military rule in every way, including for domestic law enforcement. After the end of Reconstruction, when Southern states again got representation in Congress, one of the first things they did was pass the Posse Comitatus Act. Rarely in American history since have troops been used in domestic situations. The last time it occurred without a governor's request was in 1965, when President Lyndon Johnson sent troops into Selma, Alabama, to protect civil rights demonstrators. The last time it occurred with a governor's request was in 1992, when there were riots in Los Angeles following the acquittal of the police officers who beat Rodney King, and Governor Pete Wilson asked President George H.W. Bush to send in troops. There is no doubt that what the president is doing in nationalizing state guards and sending them into cities is for the purpose of domestic law enforcement. Lest you have doubt, you only have to read the words of President Donald Trump that said this is what he wants to do. And he's done it in Los Angeles, he's done it in Washington, D.C., he's done it in Portland, he's done it in Chicago. So far, court after court has ruled this illegal. Most recently, the United States Court of Appeals for the Seventh Circuit, Federal Court of Appeals that covers Chicago, with a panel of judges that included both Democratic and Republican appointees, found the use of troops in Chicago was illegal, in violation of the law. The Trump administration has taken that matter to the Supreme Court, where it now sits. But let me give you another example of blatantly illegal activity, and that's President Trump's invocation of the Alien Enemy Act of 1798. The Alien Enemy Act says that if the United States is in a declared war or faces imminent invasion, then it can summarily deport, quote, males over the age of 14. We're not in a declared war. There's no imminent invasion. And yet President Trump has invoked this statute to deport 300,000 individuals from Venezuela. Again, the federal courts have found that this is illegal. This is a statute that's only been used 3 times before in American history. During the War of 1812, World War I, and World War II. Tragically, it was used in World War II to facilitate the evacuation and internment of Japanese Americans on the West Coast. There is no plausible argument that the Alien Act of 1798 applies in these circumstances, but President Trump is using it. Another example of the illegality of the Trump administration is the revocation of birthright citizenship. A little bit of background here. When the country began, it followed English law that anyone born in the country was a citizen of the country. The Supreme Court tragically departed from that in 1857 in the case of Dred Scott versus Sanford. There, the Supreme Court held that enslaved individuals were not United States citizens, even if born in this country. When the 14th Amendment was drafted and ratified a decade later, the first sentence was expressly to overrule Dred Scott versus Sanford. It says, all persons born or naturalized in the United States are citizens of the United States and of the state wherein they reside. It says within the jurisdiction thereof, and the Supreme Court told us what that means in 1898 in United States versus Juan Camargue. It's a case that arose not far from here in San Francisco. And the Supreme Court said the first sentence of the 14th Amendment means exactly what it says. Everyone born in this country is a citizen, regardless of the immigration status of their parents. The court said the phrase within the jurisdiction thereof just means if there was an invading army and the soldier had a baby, or the foreign diplomat who had a baby, those children wouldn't be citizens. Correspondingly, if there's an American soldier abroad or an American diplomat abroad who has a baby, those children are citizens. That's been the law since 1898. If you go back from the 14th, it was adopted 1868 without exception. No one questioned it. Until January 20th, President Trump issued an executive order saying, essentially, only those born to citizens or those with green cards are United States citizens. So far, many federal courts have ruled on this, and everyone without exception has said the Trump executive order is unconstitutional. I will give you some other examples that go along that support this idea that the president is repeatedly, blatantly violating the constitutional laws of the United States. A second example that I gave was how the president is, in a way that we've never seen before, aggrandizing executive power, increasing the authority of the president. Let me once more give illustrations. The president's efforts to eliminate federal agencies, including cabinet departments. The president has eliminated the United States Agency for International Development and the United States Department of Education. Both the United States Agency for International Development and the United States Department of Education were created by federal statutes. Congress could pass a law to eliminate these agencies, but the president has no authority to do so. Another example is the president's claim that he can fire anyone in the executive branch of government, even when there's a statute that prohibits removal. A little bit of background here. In 1935, in Humphrey's Executive versus United States, the Supreme Court concluded that Congress can create federal agencies and Congress can provide that the members of the agency can be fired only for just cause. That case involved the Federal Trade Commission. There's a federal law that says that those on the Federal Trade Commission can be fired only if it can be shown there was cause for firing. Cause is defined in the law. The Supreme Court unanimously upheld this. And no president for the last 90 years has questioned Humphrey's executor. President Trump said he's not going to follow it. He said he believes there's a unitary executive and he has the right to fire anyone in the executive branch of government. And he has done this repeatedly. Gwen Wilcox is a commissioner on the National Labor Relations Board. Her term extends to 2028. She can be removed only for cause. President Trump fired her with any assertion of cause. Kathy Harris was the head of the Merit System Protection Board, an important federal agency that protects government workers. Her term extends. She can be fired only for cause. And the president fired her. The members of the Consumer Product Safety Commission, by statute, can be removed only for cause. President Trump fired all of them. Lisa Cook is a governor on the Federal Reserve. There's a statute that protects them from removal without cause. President Trump has removed her as well. This is a claim of presidential power that we've seen from no other chief executive. But it goes further than that. Civil service has existed in the United States since the 1870s. Civil service provides protection from removal. President Trump has taken the position that civil service is unconstitutional and has fired thousands of government workers, notwithstanding the protections offered by law. And one more example that shows both the claim of unprecedented executive power, but also lawlessness, is President Trump's claim that he can refuse to spend money appropriated by Congress. Under Article 1 of the Constitution, Congress has the spending power. Many would say it's the quintessential legislative power. The president has no authority to refuse to spend money appropriated by Congress. President Nixon tried this in the early 1970s. President Nixon claimed that as chief executive, he could impound money and refuse to spend that, even though appropriated by federal statute. Every federal court to rule on this said the president can't do that. That usurps the legislative power. In 1974, Congress passed the Impoundment Control Act. A beleaguered President Nixon reluctantly signed it. It, by statute, prohibits the president from refusing to spend money appropriated by Congress. We have seen countless instances, January 20th, where President Trump has said he's not going to spend money appropriated by Congress. This includes money for things like United States Agency for National Development, Center for Disease Control, but I'd especially focus on universities. His cutting off $400 million from Columbia, $2 billion from Harvard, $585 million from UCLA. All of these are illegal. Now, what President Trump has claimed is that he's doing this because these universities have not adequately dealt with anti-Semitism. I want to suggest to you that's using anti-Semitism as a pretext. And the reason I say this is there's a federal statute that says, in this Title VI of the 1964 Civil Rights Act, the recipients of federal funds can't discriminate based on race or ethnicity. And President Trump wants to claim that a university is violating Title VI. The law specifies the procedures to be followed. A university has to be given notice of the charges against it. There has to be a hearing before an impartial decision maker. The impartial decision maker has to find that the university did discriminate or create a hostile environment. Before any funds can be cut off, the statute says there has to be 30 days advance notice to both the House and the Senate. And when funds are cut off, it can only be as to the part of the program that itself violated federal law. The Trump administration followed none of those procedures. So at the very least, it's again an illustration of illegal presidential acts, but it's also an attempt to tremendously increase the power of the presidency to take over the spending authority of Congress. Well, I said at the beginning that what concerned me so much was the illegality, the efforts to increase executive power, and also the use of executive power to punish for retribution. We saw some of this from Richard Nixon in the early 1970s, but never in the way that we've seen over the last 9 months. Let me talk about the executive orders targeting law firms. One of the very first of these targeted the law firm of Perkins Coie. It's a Seattle law firm that has offices in many cities, including San Francisco and DC. President Trump issued an executive order, and in it he said that none of the lawyers from Perkins Coie could have security clearances. None could continue to enter any federal building, which would include any federal courthouse, and the federal government would not contract with any clients who are represented by Perkins Coie. No law firm can exist under those conditions. Lawyers need to be able to go to court. They need to go into federal buildings, talk to agency officials. They need to have clients and those who can contract with the federal government. So you have to ask, what is it that Perkins Coie did that was so bad to deserve these draconian punishments? The executive order says so explicitly. They represented Hillary Clinton in 2016. 2 other law firms got targeted with the exact same sanctions. The law firms of Jenner and Block and Wilmer Hale. What was that they did that was so bad? One of them hired Robert Mueller, and another hired lawyers who worked for Robert Mueller. And the final law firm that got targeted by executive order that's fighting back is a law firm called Sussman Godfrey. It's a law firm out of Houston, has offices in Los Angeles and DC. And again, you can ask, what did it do that was so bad? It represented Dominion Voting in suing Fox News, a case that ultimately settled for $750 million. To me, what's so stunning about these executive orders is they're explicit. They say that the sanctions are being imposed for the sake of retribution. No other wrongdoing is alleged by these law firms. We've also seen the use of power for the sake of retribution in the indictments of James Comey, Letitia James, John Bolton. In fact, when there was a United States attorney who wouldn't indict James Comey, he was fired. So a puppet could be put in place who would then indict Comey. The government, the president, tremendous power, and it's being used in a way we've never seen for the sake of retribution. I could go on with many more examples of this, but at least you can see why I say at the beginning that what we're observing is unprecedented and why it's such a threat to democracy. Well, that brings me to the second part of my remarks. Will the guardrails of democracy hold? Will there be checks and balances? And I said in my introduction, at this point in time, we just can't know. Certainly, those who are surrounding President Trump aren't going to be the checks and balances on what he's doing. Can you imagine Kash Patel, or Pete Hegseth, or Pam Bondi being there saying, no, you can't do this? During the first Trump administration, there were people there who said that. After the tragic death of George Floyd, when President Trump wanted to send troops into cities, he was told that he couldn't do so. He didn't have authority. This time, though, he surrounded himself with people who will only say yes. Will Congress be a check on President Trump? Is there even a Congress at this moment in time? So far, Congress has just been a rubber stamp, whatever Trump wants. So that means that we rely on the courts to protect the guardrails of democracy. And will the courts do this? Can the courts do this? So far, the lower courts throughout the country have been terrific in issuing temporary restraining orders, preliminary injunctions, permanent injunctions against what President Trump has been doing. I'll tell you of one case that affects the University of California, including the Berkeley campus, a case where I'm very proud to be one of the lead counsel. In early June, 2 law professors and 2 law firms, pro bono, filed a lawsuit on behalf of the faculty and researchers at the University of California who had had grants cut off. At that point, by the Department of Government Efficiency DOGE estimate, about $325 million of grants to UC researchers have been cut off. I actually believe that that's a tremendous underestimate because we knew so many grants that weren't on the DOGE website that had cut off. And also, it didn't include subgrants. My guess it was close to about $750 million. And a federal district court on Monday, June 23rd, issued a preliminary injunction saying that all of the grants cut off by the National Science Foundation, as well as the Environmental Protection Agency, the National Endowment of Humanities, had to be restored. Why these 3 agencies? Because the plaintiffs who were named in the complaint had grants from these agencies. And the Trump administration complied with the judge's order, and a number of researchers, including on this campus, got their grants restored. And the United States Court of Appeals for the Ninth Circuit agreed with the district court, and the grants needed to continue to be provided to faculty and researchers. On August 1st, the National Institutes of Health and other agencies, as I said, cut off $584 million of aid to UCLA. We went immediately into court and said, the Trump administration is contempt because at least as the agencies that there was the order that they couldn't cut off grants, NSF, EPA, NEH, the Trump administration has done just what the judge forbid. And the judge on August 12th found the government in contempt and ordered $86 million of grants from the National Science Foundation restored. We then went back into court and said we want to amend our complaint to include the National Institutes of Health, as well as the Department of Defense and the Department of Transportation. And the judge agreed. And we estimate that probably about $500 million in grants were restored as a result of this. The case is going to be argued again. I'll argue it a week from Friday, November 14th, in the Ninth Circuit. But so far, we've won in the lower courts, and a large amount of money has been restored. And it's, of course, not just our case. A federal district court in Boston found that the cutoff of funds to Harvard violated the First Amendment in order to be restored. And I can go through all the examples I mentioned earlier and how the lower courts have consistently ruled against the Trump administration. The problem is when the matters have gotten to the Supreme Court almost without exception has reversed the lower courts and upheld what the Trump administration was doing. Remember, just a moment ago, I mentioned the individuals who were fired by Donald Trump, Gwen Wilcox and Kathy Harris, and the members of the Consumer Product Safety Commission. The lower courts ruled in favor of them based on the longstanding Supreme Court precedents I told you about, but the Supreme Court reversed. Well, let me give you another example where the Supreme Court has reversed the lower court, and I think in a way that's particularly tragic. This summer, the federal district court in Los Angeles found that ICE agents were violating the Fourth Amendment and stopping individuals without reasonable suspicion. The Fourth Amendment covers police searches and seizures. Police stops are a form of a seizure. And the Supreme Court has always said that the police can stop somebody, and ICE count as police, only if there's reasonable suspicion. And the judge found that ICE was violating the Constitution. The judge concluded that ICE was using 4 factors, none of which he said individually together can be a basis for stopping individuals. A person's apparent race or ethnicity, the language they speak and whether they have an accent, the type of job they work at, and where they're located. The government went immediately to the Federal Court of Appeals to get a stay of the preliminary injunction. And the Court of Appeals for oral arguments on a Monday and on Friday, in a 55-page opinion, they agreed with the district court. But on Monday, September 8th, the Supreme Court stayed the district court's preliminary injunction. In other words, allowing ICE to continue to do what it was doing. And the Supreme Court wrote no opinion, not a word of explanation. Justice Kavanaugh wrote an opinion for himself. Justice Sotomayor wrote a scathing dissent, joined by Justices Kagan and Jackson. But the Supreme Court stopped the district court order without a word of explanation. I'm teaching criminal procedure this semester at the law school, which covers the Fourth Amendment. So on the day after this came down, Tuesday, September 9th, I began class by talking about it. We spent a good deal of time in class talking about the standard for reasonable suspicion, the standard when police can stop individuals. After I presented the case, there was discussion. There's about 200 students in the class. And a woman raised her hand and said, my father lives in Los Angeles. He's Latino. He's a citizen. He speaks with a thick accent. He's retired now and likes to work around the house. He often goes to places like Home Depot. She said, I'm petrified every day that he's going to be arrested. She burst into tears. And another student crying had a similar story. The next day, a student in the class came to me. His mother had been apprehended in Los Angeles by ICE. After 2 days, she was released. The Supreme Court, in a matter that concerns basic freedom, didn't even write an opinion. Now, I think there's also the question of if the Supreme Court steps up, will President Trump, will the Trump administration listen? One of my great fears is that the Trump administration will just ignore judicial orders. What happens then? Well, a court can enforce its order by holding someone in contempt. Contempt can be a criminal punishment, but President Trump can't be prosecuted for any crime he commits as an official act. The Supreme Court ruled that in Trump versus the United States in 2024. And also the president can pardon anyone convicted of crime. There's civil contempt, where somebody is held in jail or fined until they comply with the court order, but that's enforced by the United States Marshals, who operate under the direction of the Attorney General, Pam Bondi. President Trump has said, and I quote, he who saves the country violates no law. Vice President J.D. Vance has said the president doesn't have to follow court orders that intrude on his powers. What happens if the courts rule against President Trump and he ignores the orders? And I think that is truly the end of our democracy as we know it. Because if the president can violate the law and ignore court orders, then the president can literally do anything. He can lock up you or me or any of us, and no court would be able to protect us. That we even are having this conversation shows why I'm so fearful of the future of democracy. So let me conclude by briefly talking about what can we do about it. I think we have a responsibility. I think history may well judge us on what did we do while we were watching all of this happening. One thing I think we need to do is be informed and help inform others. I've heard so many people say, I've stopped reading the newspaper or listening to the news because it's just too depressing. We can't afford to do that at this moment in time. And I think for those of us who have the opportunity, we have a real obligation to help educate others. The kind introduction mentioned the project, We Hold These Truths. I'll just say a word about that. I was talking to a law professor at another university this spring and saying, I think our country does a terrible job of civic education. What can we do to better inform people? We said, what if we got together, about 20 people, Democrat and Republican, and tried to write a statement of basic principles of constitutional democracy, and then used it as a basis for civic education. And I reached out to people. I went to Michael Ludig, a former federal court of appeals judge, who's quite conservative, and asked him to be my co-chair. We got some prominent Democrats to be in our group of 20. Stacey Abrams was one of them. Pete Buttigieg was one of them. Jamie Raskin was one of them. We got some prominent conservatives. We had Christine Todd Whitman, the former governor, Brian Sandoval, the former Republican governor of Nevada. We got Wesley Clark, the former general. We got some prominent academics, Melissa Murray, who used to be at Berkeley's NYU, Harold Koh, the former dean of Yale Law School. We got a couple of federal court of appeals judges who are now retired, one liberal, David Tatel, one conservative, Tom Griffiths. And we set out in a relatively short period of time, and we divided ourselves into 5 groups. One was focused on the rule of law, one on democracy and elections, one with regard to separation of powers, one on personal freedom, and one on equality. And 5 can go into 20, so there were 4 in each group. And amazingly, each group came up with the goal was 3 to 5 principles. We wanted it to be short enough that it could all fit in an ad in the New York Times on July 4th, and long enough that it wasn't just platitudes. And then all the groups sent in the principles. I edited for stylistic consistency, and then we negotiated so that everyone was willing to sign on, and all 20 signed on. And it appeared as an ad in the New York Times on page A7 on July 4th. It was page 3 of the San Francisco Chronicle, appeared in a number of other newspapers. And then on September 17th, Constitution Day, it appeared in a number of other newspapers, including the Wall Street Journal. Democracy Forward has taken it over and is now being used for public education. Recently, actress Julianne Moore did a video based on it. The author Brad Meltzer did a video based on it. He's writing a children's book. You can find it online, just as weholdtruths.com. And we're getting people just to sign on that they agree with our principles. But again, it's all part of trying to get people to be informed. Second, I think it's really important that we be involved. There's lots of ways to be involved. There are many organizations that are doing terrific work. I mentioned Democracy Forward, there's Protect Democracy, the ACLU, Common Cause. They need our help. They need volunteers. They need financial support. Go on with other ways that each of us can find to be involved. And finally, we have to speak out. There's so many ways of speaking out. Maybe it's speaking out by sending letters to members of Congress. They really do pay attention to them. Maybe it's speaking out by signing petitions. Maybe it's speaking out by going to rallies like the No Kings rally a few weeks ago. But there's such an obligation that we not be silent. I'm sure you all know the very famous quote from the Pastor Martin Niemöller, but I think it's where I'll conclude and then take your questions. He said after being released from the concentration camp that they came for the trade unionists, and I didn't speak up because I wasn't a trade unionist. So they came for the communists, and I didn't speak up because I wasn't a communist. They came for the Jews, and I didn't speak up because I wasn't Jewish. He said, then they came for me, and there was no one there to speak up. I think it's so important that we, our generation today, not be in a position years from now to echo words like Martin. So thank you, and I'm glad to take your questions.
You want us to sit here?
Oh, easier for me given that
Yeah, you can stand or sit,
Okay.
whichever.
I'm short, and at least I can see people in the back.
Well, maybe I can start off some of the Q&A by saying, I don't know if you're aware of it, but there's this Proposition 50 that folks are voting on tomorrow. And there seems to be some kind of arms race, sort of a gerrymandering, counter-gerrymandering arms race in the country. So I was wondering what you thought about that. And the second part of the question is that even going to matter when the Supreme Court looks at Section 2 of the Voting Rights Act?
Let me take each of the two questions separately. In terms of Proposition 50 and gerrymandering, gerrymandering was the political party that controls the legislature, draws election districts to maximize seats for that party. As we say, a Republican state legislature draws election districts to maximize seats for Republicans, or a Democratic city council draws city council districts to maximize seats for Democrats. Gerrymandering is nothing new. It takes its name from a governor of Massachusetts early in American history, Elbridge Gerry, who engaged in the practice. He drew legislative districts, and a newspaper said one looked like a salamander, and thus the phrase gerrymandering. But what's changed is that because of sophisticated computer programs and detailed voter information, it's possible to engage in gerrymandering with far more precision than ever before. Take North Carolina as an example. It's a purple state. It went for Obama in 2008, Republican candidates, but always by very close margins. In congressional elections in North Carolina, Democrats and Republicans get almost exactly the same number of votes. But there are 10 Republican seats in Congress in North Carolina and 4 Democratic seats because of gerrymandering. I have argued for a long time that gerrymandering should be deemed unconstitutional. And when the Supreme Court first ruled on it in Davis versus Vandermeer, it said it was unconstitutional. But in 2019, in Rucho versus Common Cause, a case from North Carolina, the Supreme Court said no federal court can hear a challenge to partisan gerrymandering. The solution is for states on their own to have independent commissions to draw districts, rather than have it go to the legislature that does it to protect seats for incumbents in their party, have an independent commission. I strongly supported the California initiative for an independent commission. I strongly supported a bill that passed the House of Representatives twice, just in recent years, when there's a Democratic House, that would have required independent commissions for all congressional seats in the United States. Unfortunately, only a handful of states, like California, have independent commissions. President Trump urged Texas to redraw districts to create more safe Republican seats. It's unusual to redraw districts in the middle of a decade. Usually the districts are drawn right after the census, usually not redrawn again for a decade for the next census. But there's nothing in the law that prevented Texas from doing this. And then North Carolina and Missouri each did this and created one additional district. And it was in this context that Governor Gavin Newsom, the Democrat, said that we should suspend the independent commission so that California can engage in partisan gerrymandering and create more Democratic districts. I don't like it, but I like unilateral disarmament more. That I wish that every state had independent commissions. I wish no state engaged in partisan gerrymandering. But all I can say is the reason I voted for Prop 50 is just what I said. As much as I dislike partisan gerrymandering, I dislike unilateral disarmament more. And I think that it's about checks and balances. Totally separate question you asked. concerns Section 2 of the Voting Rights Act, and this has nothing to do with partisanship. I regard the Voting Rights Act of 1965 as one of the most important laws adopted in my lifetime. In 1964, in Mississippi, only 7.6% of eligible Black individuals were registered to vote. Almost 70% of white individuals registered to vote. In Alabama, in 1964, only 19.5% of eligible Black individuals were registered to vote. In the states that comprised the Confederacy, in 1964, only 33% of eligible Black individuals were eligible to vote. The Voting Rights Act of 1965 changed that. And it did so in two major ways. First, it said that any jurisdiction with a history of race discrimination in voting needed to get pre-approval, pre-clearance before it changed its election system. This was tremendously successful. There are hundreds of instances where they didn't get pre-clearance. The discriminatory change in the election system weren't allowed. But on June 25th, 2013, in Shelby County versus Holder, the Supreme Court declared the pre-clearance requirements unconstitutional. Chief Justice Roberts, who wrote for the court, it's 5-4, said, but there's still another provision of the Voting Rights Act, Section 2, the one that you referred to. Section 2 says that state and local governments can't have election systems that discriminate against voters of color. And Congress in 1982 amended that to make clear that state and local governments can't have election systems that have a discriminatory effect against voters of color. On October 15th, just a couple of weeks ago, the Supreme Court heard oral argument Louisiana versus Calais, where the Supreme Court is considering declaring Section 2 of the Voting Rights Act unconstitutional. I think the Supreme Court, based on oral argument, is going to either dramatically narrow Section 2 or declare it unconstitutional, gutting what's left of the Voting Rights Act. Now, that has nothing to do with partisan gerrymandering, but it will have an enormous effect with regard to elections, and particularly the representation of minority voters. I'll go in the back and then here and then here.
Okay, so I wanted to say something about, you posed the question of what can we do? And I think that there needs to be a massive uprising of resistance, a political earthquake from below, of people who see that what we're facing is unprecedented, like you said, as well as people and institutions refusing to go along with, as you said, it's unprecedented, and I would add, it's a fascist regime that we're facing now. I also think there's an urgency to acting now, because just in the last 10 months, as you laid out, all these things that had happened that we have never seen. So I just wanted to know what you thought about that, that people need to act, not relying on the courts or the Democrats, and the time is running out, but we still have some time.
And on the one hand, it was encouraging that 7 million people, it's estimated, went to rallies 2 weeks ago. The rally here in Oakland, and it was amazing how many people were there. On the other hand, when I heard of President Trump's reaction, I first thought it was a South Park episode, that he had a sketch where he was dressed as a king dropping excrement on people. It's astounding to me that we have a president who would do that. But hopefully the number of people will grow, and that will matter in terms of what Congress does, even if it doesn't matter to President Trump. And there are midterm elections a year from tomorrow, and they could matter enormously as well. So yes, I obviously totally agree with you. People need to speak out. Democracy dies in silence. Democracies don't die. People rise up.
So, speaking of elections, I think, it's like, I'm wondering what is his point? I mean, other than, that he obviously thinks all cities are killing everybody and all this crime is happening, but I think I can't tell whether he wants to steal the election if it's close enough, or he wants to cancel the election. I don't really know what he's doing with all these troops, and it's pretty bad in my opinion. put,
I don't see a likelihood of canceling an election. I don't see a likelihood of Donald Trump having a third term in office. But
I don't think, I think he's.
there is
He's
no
not
constitutional path to having a third term in office. But what I do think he's trying to do is normalize the presence of troops in cities, normalize the presence of troops for domestic law enforcement. And that in itself is very frightening. There's no authority under our Constitution or federal law for martial law. And yet, presence of troops in this way is such a large step in that direction. I worry about the use of troops and federal agents to intimidate voters. Will Latino voters who are citizens be afraid to go to the polls if they know that ICE agents and troops are there? So that's what I worry about. Your next minute.
Thank you. Thank you for the talk. I'm curious, I want to push you to address whether you think the politics inside the Supreme Court are, that there lay in there a possibility of so far and no further. I mean, I think back to 2013 when John Roberts saved Obamacare, a 5-4 thing, on the basis that it seemed he didn't want to go down as a Supreme Court that was ideological. That seems to have faded. Is there, in your view, a potential for, on the Supreme Court, a doctrine which comes to this far and no farther?
I don't know if you could hear the question in the back. It was, is it possible within the Supreme Court that they will draw a line of this far and no further? And of course it's possible. And I'm hopeful. I think there will be instances where the court is likely to rule against President Trump. I think they're likely to rule against him on birthright citizenship. As I said to you, given the history, the text of the 14th Amendment, the precedent, the tradition, I think Trump is going to lose that. I think there's a real chance he can lose the 2 tariff cases. They're going to be argued. They're going to be argued on Wednesday. There's no statutory authority for the tariffs. When laws are meant to give the president power, they say so. And under traditional conservative doctrines, I would think the justices might rule against him. So I think there will be this far no further. But where will that line be drawn? Over the summer, I speculated that there might be a line between separation of powers cases where the Supreme Court would go along with the president and individual liberties cases where they wouldn't. And then on September 8th, Noam versus Perdomo came, where they said that they weren't going to stop ICE agents from stopping people without reasonable suspicion. So it's clear that wasn't the line. It's a different court now than it was when the Obamacare case was decided, because there are 6 conservative justices. 5 of them don't need Roberts' vote. And I think Roberts knows if he wants to be the Roberts court, he needs to go where the other 5 conservatives will go, even if it's further to right than he might want to. Occasionally, he has dissented in some of the cases this summer, but for the most part, he's been with the conservatives. I'll answer your question with a question. There is no doubt that Justices Sotomayor, Kagan, and Jackson are deeply afraid. If one of them was here, was candid, I think they would give the same talk to you tonight that I just did. But how afraid are John Roberts or Amy Coney Barrett or Brett Kavanaugh? They haven't expressed that fear yet. Do they feel it? Are they not checking the president because they're afraid their orders will be disobeyed? Or are they really just part of Team Trump? We don't have the answer to that question now, but our democracy could depend on that answer.
Are there certain countries like Hungary or others that you think are useful historical precedents that we can look at, or are there models, or you feel like it's very US sort of centric, this current context, and we need to really focus on?
I think what we can do in that regard is look to countries that were democracies that then became authoritarian. There was an article in yesterday's New York Times. It's the editorial by the editorial board, and you can find it online, where it talks about what's the evidence that the United States is moving towards authoritarianism. And it comes up with 10 factors, much like the ones I was talking about tonight, and where we are on that scale. So if you look at what happened in Hungary or Turkey, I think you can see things that we're doing that are similar to exactly what occurred in those countries where democracies died. If you want to look for countries where democracies survived, it becomes harder to translate it to the United States because our system of government is so different. But if you haven't seen that New York Times, it's literally yesterday's paper and it's online. There's right here, please.
Just like we don't like the idea of unilateral disarmament and gerrymandering, districting. What's wrong with people who are charged through their offices with defending the Constitution from doing something like a constitutional version of Doge? That they sort of invented Doge out of whole cloth. So why can't the U.S. Marshal Service invent something that can just hold the heads of the agencies, the Trump-appointed heads of the agencies, in civil contempt, and actually physically remove them from office and put them under some kind of detention until they stop violating the Constitution?
I think it's very important that what we do to check the Trump administration be lawful. I don't think that doing unlawful things is the way, because then there's ruling no longer under a rule of law, and then it's whoever has the most power. A federal judge can hold somebody in civil contempt for violating a court order. Civil contempt means that the person will be put in jail or fined until they comply with the court order. And so if a court issues an order and a government official refuses to comply, the judge can say, you're in jail until you comply with my court order. The problem with that is the person who puts that person in jail is the United States Marshal, and the Attorney General commands the United States Marshals. So that's what makes that unlikely. Could there be a point at which soldiers say they won't follow unconstitutional orders? Or marshals will say they won't follow unconstitutional orders? Soldiers are trained both to follow orders and not to follow unconstitutional orders. Their oath is to the Constitution, not to the president. So far, we haven't seen that. Maybe we will. It's very frightening.
Can I sneak in a couple of questions from some of the?
Oh, of
folks
course,
on
I'm
our
here for
Zoom?
you.
Yeah, these are great questions, by the way. One of these is how should UC respond to Trump's demand to align with its priorities and values, or else? And the other question was, what do you think is the strongest democracy in the world?
As the first, I think the University of California should fight back and fight back as hard as it can. When the Trump administration cut off $584 million to UCLA on August 1st, the University of California should have gone to court and filed a lawsuit against that. They didn't. When the Trump administration, Department of Education Office of Rights, asked the campus reveal 160 names of people, and my wife was one of those 160 names and got the letter from campus council, the Trump administration should have said no and should have gone to court to fight against that. And I can go on and explain why under the law I think they could have won. I'm very disappointed in the administration of the University of California that it hasn't fought back, that apparently they're afraid that if they file suit, there'd be greater retaliation against it. But I think we all learned on the playground, if you give in to a bully, you only make it worse. I'll still say I think the United States is the strongest democracy in the world for all practical purposes. It's the longest continuing constitutional democracy that's existed, but I'm afraid. I think we have time for just a couple more questions. A question here and a question here.
Professor, what kind of precedent do you think his actions are setting, in the sense that would this be like a one-off, or if something were to happen to him, for example, with J.D. Vance, took over, would he continue doing something like this? And in that case, like what checks and balances do you think would need to be introduced to kind of prevent something like this in the future?
I don't think at this moment in time we can know the answer to your question. How much of what we're seeing now is because of a unique demagogue as president, and this country's never had a demagogue as president before, and that after this, we'll go back to politics as normal. President Trump's approval ratings in the polls this morning were 36%. And my own sense is that probably 35% of the country will follow Donald Trump, including the fascism. 35% of the country is deeply afraid. And the question is, where's the other 30% of the country? And so perhaps the response to what Donald Trump is doing, what I detailed, will be much like the response was to Richard Nixon, a whole series of laws adopted to check executive power. Or perhaps what we're seeing is a movement that will only continue and grow. J.D. Vance is elected in 2028, or somebody else from the MAGA movement. But I don't think we can know at this moment in time. And as I say, after Richard Nixon, there were reforms, went back to normal. Even after Donald Trump's first term, which was nothing like the second term, we had a return to a form of normalcy. Will people want that? Our country is more deeply ideologically polarized than it's been at any time since Reconstruction. What will that mean? And to tie that to where I started my remarks tonight, can democracy survive if a country is as deeply ideologically divided as the United States? There's one more question, there's one more hand, please.
So thank you so much, first of all, for your talk. It's very, it's very powerful and moving. I'm wondering about, what fuels a lot of this is the new tech industries and structures and AI and the lack of policy frameworks and ability to control those industries in the way that there should be controls in place. I'm curious to hear from you. How do you think that, is playing a part, and also what, from a legal standpoint, can be done to, slow down these monopolies and oligarchies?
I don't know. AI is not my field, but we have one of the leading experts in the country and the world sitting here, Colleen Chen, my colleague on the law school faculty. And I'd encourage you to invite her to come answer that question about AI, whether it's a threat to democracy and what can be done. But Colleen is really the expert on that. There was one more question I saw. Please.
Oh, I'm curious what you think an American totalitarianism would look like. I mean, if Trump, for example, is a Trojan horse, I mean, there's a radical difference between this administration and the first administration.
That's right.
And this administration is deeply, institutionalized with highly conservative, powerful, capable people who know how to manage systems and how to sabotage systems and have enormous money. So Trump is like an entertainment system and to distract us and to continue a devotion to whatever it is he represents to people, despite the obvious contradictions. So let's say Trump passes on and J.D. Vance or someone comparable to him who has the support of Silicon Valley, the oligarchy, the various power centers of radical conservatism, what would an American dictatorship look like?
I think it's important to know that most dictatorships don't arise from a coup or in a single moment in time. They come from a series of steps that are taken. And if I had to answer your question, I'm going to give an example and then we'll be done. This spring, the Trump administration took a man Kilmar Abrego Garcia and moved him to a maximum security prison in El Salvador. And they said once he was there, that no court had the authority to give him release. No court could even hear his case. And Trump said, we're going to ask El Salvador to build lots of maximum security prisons. Imagine that the Trump administration decides that what they're going to do with their critics is take them to El Salvador and they're going to ignore any court order that order these individuals released. It's not inconceivable when you listen to what President Trump was saying in March. It's chilling. That would be the point at which we're no longer a democracy, we're then under a dictatorship. Thank you so much for having me and coming tonight.